G'day, my name's Robert Gowdy, and during this session I'm going to discuss payments from superannuation death benefits and who gets your superannuation. So, who decides what happens to your superannuation savings when you die? Now you may think that you do, but it isn't always the case. The ultimate decision may be made by someone that you don't even know, and that's the trustee of your superannuation fund. Now let's look at how you can have greater control over this. Now, the most certain way to direct a payment of your superannuation death benefits is by making a binding death nomination. The nominated beneficiaries must be financial dependents, so a spouse, de facto spouse, child, financial dependent, or a personal legal representative, i.e. the executor or the administrator of a deceased estate. If the nomination has been properly signed and witnessed and is still current at the date of death, then the trustee of the superannuation fund must pay the death benefit to the nominated beneficiaries. Unlike wills, valid binding superannuation nominations are unlikely to be overturned by a court, although this is yet to be fully tested. So they do provide great certainty. Now it's up to each trustees of each superannuation fund to decide whether or not to allow binding nominations. So they aren't available to everyone, and you should check with your superannuation fund to see if they have them. Binding death nominations are generally only valid for 3 years, so it's important to ensure that you keep them up to date. Now, there are some options and some superannuation funds that they do allow for a non-lapsing nomination, so again, check with your superannuation fund. Now, the trustees of your super funds are under a legal obligation to pay your death benefit to members' dependents. And in most cases, it'll be paid in a way that's consistent with the wishes of the deceased member. However, it is possible that the trustee may recognise a wider range of dependents than the member would like to have had, and that includes a separated spouse, for example. In some cases, the member's preferred beneficiary may not meet the legal definition of a financial dependent, and a good example of this might be someone's parents. In the absence of dependents and a legal representative, the trustee may exercise their discretion and pay the benefit to a non-dependent. The situation is a little different if the member has already retired and is drawing a superannuation pension. With pensions, it is common to nominate a surviving spouse as a reversionary beneficiary. This means that the pension payments will continue to be paid to the nominee either until their death or until the funds run out. If the reversionary beneficiary dies, then the remaining balance is paid out as a lump sum death benefit. Increasing levels of wealth are being held via superannuation, and the nomination of beneficiaries should be made in the context of a comprehensive estate plan. This should include taking into account the way your superannuation death benefits are taxed and when they're paid to different types of beneficiaries. Your financial planner can help you with these issues and to help you make the right decisions. So again, thank you for taking the time to listen. This is general information only, and it does not take into account your personal circumstances. So please read our general advice disclaimer. Thanks very much.